The co-convener of Good morning to one and all. I, Dipesh Gulgulia, the co-convener of Society for Constitutional Law and Human Rights,
And I, Kritika Mehendirata, the Principal Secretary for SCLHR,
heartily welcomes you all on the behalf of Society for Constitutional Law and Human Rights to the guest lecture on the theme of the Indian Constitution, Conversation with Powers. I warm-heartedly welcome our esteemed guest speaker for today's guest lecture, Mr. Gautam Bhatia sir, on behalf of entire society. Thank you so much, sir, for gracing the institution with your presence. I would also like to extend a warm welcome to our Dean School of Law, Mr. Abhishek Sinha sir, our faculty convener, Ashutosh Tripathi sir, our cluster head, Shikha Dimbri ma'am, and all the professors present here, and also students.
talking about UPES. UPES is a university comprising of 8 schools that provide education in engineering, computer science, design, health sciences, modern media, liberal arts, management and law. UPS is also an NAAC accredited A-grade institution certified with 5-star ratings in the categories of employability, academic development, program strength and facilities. The School of Law at UPES is a beacon of legal education in India. Our curriculum is thoughtfully designed using interactive learning methodologies and delivered by leading experts in respective fields. We offer a state-of-art infrastructure featuring an in-house moot court for immersive learning experience. These concerted efforts have contributed to the law school's prestigious 52nd rank in the NIRF 2023 rankings for legal education.
So, to tell you about our society is first and only student established society in our college. It was established on the auspicious day of Independence Day, that is on 15th of August 2018, under the esteemed aegis of UPS School of Law. The Society for Constitutional Law and Human Rights is committed to fostering research and expanding students' understanding of evolving legal landscape. Our guest lecture series aims to dynamic platform that strive to generate awareness on crucial matters pertaining to comparative constitutional law and human rights. This platform allows us to delve into the profound concept of constitutionalism, constitutional morality, and their application in contemporary society.
With that being said, I would now like to take the opportunity to introduce you all to our esteemed guests. There is for sure so much to add to Sir's experience and learning, but we would keep it short. Sir is a constitutional law lawyer and a legal writer. We heartily and warm-heartedly welcome you, sir.
Now to take this event, I request Mr. Abhishek Sinha sir to welcome our chief guest for please present moment two. Please come.
Now I would like to invite our respected dean, sir, Mr. Abhishek Sinha, sir, to kindly say a few words of wisdom for our esteemed guests.
What a fabulous way to start a Monday morning. It is my pleasure and honor to host Gautam Bhatia. He specifically instructed the students and the SCLHR committee that make his introduction very short, and they actually abided by it. But I'm gonna take that liberty, Gautam, and introduce you properly. And to be very honest, the kind of achievements he has I had to literally prepare a script. So, to quickly highlight, he's not only the constitutional law expert, but if you think of any aspirational college or university to go at, he has done it all. He's a Rhodes Scholar, went to Oxford, then Yale. So, I mean, that still itself, speaks a lot about Gautam. One interesting fact, I was looking at the picture and then I just said, you look very, very young, Gautam, and it's the same. I mean, there's no difference. So I thought he'll say, I just clicked this last year. But he said that, this is like 9 years old. So that also deserves, a big round of applause. That it looks exactly the same. Also, in this age of Instagram, he's so busy with work that he's not getting time to click pictures. Jokes apart, he has written several books on constitution. Of course, the transformative constitution is there. I think the latest one on the stand is your seal covers. He's one of the youngest constitutional law expert who has been cited by the Honorable Supreme Court, not just once, twice, but thrice. Also some of the high courts. He's also known for his constitutional law blog. So with this, I'm keeping it short, Gautam. So with this, I welcome Gautam. And I don't want to stand in between this amazing session and all of you. So once again, Gautam, welcome. And we are eagerly waiting to listen.
So, before we commence the lecture, we have an announcement that we would like to make. Since we have left a considerable time for questions, it's going to be an interactive session. We shall be providing the signed copies of Sir's latest book, which is Unsealed Covers. Whoever participates more in the interactive session. Let's see who is able to engage with the question and the audience in the best possible manner.
Can we also ask questions?
Yeah, but it is for the students only. Yeah. Now I would like to welcome our guest speaker, Mr. Gautam Bhatia sir, to the stage to enlighten us with a deeply provoking lecture on the theme of the Indian Constitution, Conversations with Power. Welcome, sir.
I always try and say keep the introduction short, but never works. Thank you for inviting me, and it's also great to see independent student-run societies so active and making these efforts to keep that culture of discussion and engagement alive. It's something that we didn't have too much of when I was in university, so it's good to see this being run by students. So the theme for my discussion is the Indian Constitution, Conversations with Power, and the attempt is to provide perhaps a new way of looking at or understanding the Constitution. And as I told them in my engagement with the society, I want to make this interactive. So I'll try and keep the remarks to around half an hour, 35 minutes, and then hopefully leave enough time for a discussion. So to begin with, as the German scholar Gunther Frankenberg memorably said, every constitution has a story to tell. There is a narrative in a constitution. And if you ask yourself what story the Indian Constitution is telling, broadly three different and often conflicting versions emerge. The first story is the story of continuity, which is that the Indian Constitution was continuing on from the pre-independence colonial regime. And those who believe in the story point, for example, to the fact that 75% of the constitutional text was directly lifted from the Government of India Act 1935. That many of the provisions and the legal structures that the freedom fighters specifically fought against were incorporated lock, stock and barrel into the new constitution. Primary among them being, for example, detention without trial, the ordinance making power that would allow the executive to bypass the legislature and more or less rule by decree, and many other such provisions. And so, from that sense, the constitution heralded a transfer of power from one set of governors or rulers to another set of administrators, but left the underlying legal, political and social structures untouched. So that is the first story, the story of continuity. The second story is a story of transformation, which goes that actually, yes, on the surface, there do seem to be similarities between the constitution and what came before. But if you dig a little deeper, you will find the intent and the purpose to actually transform. Of course, the most visible example of this being that rarely among post-independence constitutions at the time, the Indian constitution in one stroke granted universal adult suffrage. So in all other countries before that, you see this gradual process where first people with property or men with property, free men with property have the right to vote, gradually extend that to free men without property, then to free men with education, then to free men without education, and then slavery ends, it's all men. And then you gradually extend it to women, first again with property, education, and then it's a slow process with setbacks. Whereas in India at the time of independence, because of the character of our national movement, there was this complete grant of universal franchise, quite rare. And that heralded a shift from the Indians being subjects to being citizens who were bearers of rights. And that then has to inform our understanding of the Constitution and, for example, the Fundamental Rights chapter, for instance. So these are indications of transformation within the Constitution. And within that, there are two further versions. One version is that this potential for transformation was stifled for a long time. The Supreme Court began life as a broadly conservative institution whose task was to protect the interests of the landed gentry. And so for the first 20 years, the court was standing between the Constitution's transformative vision and implementing that, until post-emergency when there was a complete shift, and with the advent of public interest litigation, with the advent of expanded meaning of Article 21, right to life, that began to be realized. Whereas a more critical view has it that even after 1980, the court's record has been patchy at best. So it has expanded rights in some domains, but when it comes to civil rights, to actually enforcing claims against state power, it is not yet quite there. So differences in opinion about the extent to which that journey has been completed, but agreement on the issue of the Constitution ultimately as a document of principle being geared towards transformation. That's story number two. And third story actually is a more cynical story, which is that if you look at the Constitution carefully, you will not see any genuine principle at stake. You will find conflicting demands, conflicting impulses. Often within the same provision, you will find two different visions in tension with each other. So there is no overall coherent story to be told. And if you look at, for example, part 4 of the Constitution, Directive Principles of State Policy, you will see everything that is there, that could be there is there. So you have labor rights, you have a uniform civil code, you have anti-cow slaughter provisions, you have the environment, you have science. And if you look at the history, basically whatever the framers could not agree upon, they put into chapter 4 as something that they could discuss later on. And that actually runs through the whole constitution. So you have these three different stories, and of course, and one thing that should be taken into account is that different parts of the constitution could correspond to one or the other story. So you could have an aspect of the constitution that is conservative, it's meant to replicate colonial structures. You could have an aspect of the constitution that is transformative, and there could be parts that just, are compromises, are the results of compromise, which in itself is not a bad thing. Compromise is not a bad thing. But all these stories are both partially true and partially incomplete when looking at the constitution. So that's how we approach the text and its history and its design. But one interesting feature about these debates so far and the way they've been conducted is that the fundamental rights chapter, part 3 of the Constitution, is what dominates these debates. There's something that those of you who have studied constitutional law would perhaps notice, in the sense that the way that our constitutional law courses are structured, as per the dictates of the Bar Council, there is one entire module or course devoted to part 3, fundamental rights chapter, and then you have other parts of the constitution that are studied separately. And this is interesting because if you open up the constitutional text and look at it, you will see that the fundamental rights chapter occupies perhaps 10% of the whole constitutional text. So in terms of number of articles, number of words, perhaps it doesn't go beyond 10%. There is 90% of the constitution that is not fundamental rights. And so when we ask ourselves what story is the constitution telling or is meant to tell, the dominance of fundamental rights is something that could perhaps distort the character of that story. And if you look at, for example, how constitutional law books are organized, it's the same issue. That is one thing. And the second thing is that there is often a relationship between the fundamental rights chapter, part 3, and the other parts of the constitution that are preoccupied to a large extent, and these are large bulks of the constitution, with questions of design and structure. Or to put it another way, the question of how a constitutional document organizes power. Who does it give power to? Who does it take power away from? How does it constrain power? How does it enable power? And often the fundamental rights chapter and those questions are connected with this question in a way that's not immediately evident or visible. So the Latin American constitutional scholar Roberto Gagarella, whose books are fantastic and I would recommend them, he looks at 200 years of Latin American constitutional history, and he divides a constitution into two parts, what he calls the dogmatic and the organic. The dogmatic part is the Bill of Rights, part 3, fundamental rights, the declarations, equality, free speech, right to life, and so on. The organic part, or what he calls the engine room of the Constitution, is the question of the structures of power a Constitution sets up. And in his study of 200 years of Latin American constitutional history, what he finds is that over the years, and this may be a somewhat familiar story even for us, gradually there was this understanding of that a Bill of Rights must be expanded. So you begin with a few basic rights, right to life, due process, equality, and over the years those are expanded. So starting with the Mexican Constitution of 1917, which first laid down labor rights, for example, much before they became mainstream in the West, other Latin American constitutions began to expand the domain of rights, socioeconomic rights, third generation rights, and so on. But even as they did so, the basic structure of Latin American constitutions remained such that the president had all the power. So from the very beginning, these constitutions are presidential. So there was one elected president, directly elected, and then he had all the power. It was very hard for anyone else or any other body or institution to check or to curtail the exercise of his power. And what Gagarella then finds is that on the one hand you had expanding rights, On the other hand, you had concentrated power, and the two were simply irreconcilable because it's very hard to enforce rights in a meaningful way when one person effectively has all the power at his disposal, then you can't check their impunity in any fashion. So he says that you need to look at these two parts of the constitution together and in relation to each other. And of course, those of us who have engaged with the post-1980s history of India might see something similar, where Article 21 expands and expands and expands over time. But the fundamental concentration of power in the executive in the Indian constitution has also become greater over the years in different ways that you all know about. So then that question remains, that when we look at the Indian constitution, studying the rights chapter, looking at fundamental rights, are we actually paying enough attention to the question of how the Indian constitution organizes power, which is something perhaps that needs a greater focus. So on that note, if you go back to the history of the framing of the Indian constitution and the debates among the constitutional framers, a few interesting points stand up. So one is that broadly, when we think of a constitution or the fundamental goal of a constitution, we think of it as a very important part of a constitution being curtailing or limiting the state. So the constitution is meant to ensure that when there is a state, the state power is limited, must be exercised in accordance with a certain process, and of course fundamental rights constrain substantively what the state can do. So we think of that as being a fundamental feature of constitutionalism, something that is inherited from the US Constitution, the American Revolution, and that history. But reading the debates around the framing of the Indian Constitution, a different vision emerges, which is that for the framers of the Indian Constitution, they looked around them and they saw the degrees of poverty in the country and all the other social problems and social ills that were prevalent and very present. And in their mind, these problems could only be resolved not by limiting the state but by empowering it. So they viewed one of the important tasks of the constitution and constitutionalism as actually creating a terrain where state power could be enabled and not necessarily constrained. And if you just look at the constitution and think about it, you'll see various parts where that happens, and we can discuss that. But even, of course, as they did so, they were also keenly aware of the dangers that would entail, the dangers that come with a constitution whose primary goal is to empower, to enable the state, even the extent of power the state has. And so while on the one hand they wanted to enable and empower the state to a degree much greater than in other more classical constitutions, they also wanted to ensure that power could not be abused or used in a way that would ultimately endanger the citizens. And so in that sense, the constitution has a number of conflicting impulses. So on the one hand, there are many provisions that try to expand state power. If you, for example, look at the constitution, you will see in no fewer than 26 places the phrase "notwithstanding anything else in this constitution." So basically, even within the constitution, there are exemptions from its own application to aspects of state power. At other places, you will see, for example, the power to make widespread changes in the constitution being granted to the executive or to the parliament, with the rider that nothing in this provision shall be taken to be an amendment of the constitution for 368 purposes. So whereas normally you would have to go through 2/3 majority in both houses to amend the constitution, in a number of places you find a provision that allows you to do the same thing with just a bare majority and exempts that onerous requirement of procedure. So there are these many kinds of provisions, types of provisions, where you see that expansion of power. At the same time, of course, the impulse to limit it. And so in that sense, the constitution, and I'll give an example of this in a moment, is a terrain of contesting impulses of power. And we can understand the constitution in that way by looking at the axis along which that contestation happens. So I'll give 6 such axes, and there may be more, and when you look at the constitution you may find others, of course, this is not an exhaustive list. But there are these 6 axes that I think cover a significant part of the constitution. So the first axis is the federal axis, so center and state. The first and most important axis of power. Article 1 of course says India, that is Bharat, shall be a union of states. So you have these 2 tiers of governance, union and states. And under the 7th schedule, each tier is given fields under which it can pass laws, and there are exclusive to it, and of course there are concurrent lists as well. But that said, the Indian constitution is deeply skewed towards central power. So for example, under Article 3, the union legislature, the parliament, can alter state boundaries, modify state boundaries, create new states without the consent of the state in question. And that's of course a question that is up for discussion right now in the ongoing case involving the conversion of Jammu and Kashmir to a union territory. That's up for decision right now. So you have multiple provisions of that kind that skew power towards the union away from the states. And then the question is that when you have a constitutional silence or an ambiguity, how do you interpret that in a dispute between the state and union? That will be the example I will come to. So that's axis 1. Axis 2 is homogeneous and pluralist tendencies within the federal scheme. So if you look at Article 371 of the Constitution, at least 11 or 12 different states have different kinds of arrangements with the union, the center. This could be Nagaland, where no law that affects land and resources or customary laws or personal laws can be applied to Nagaland without a resolution passed by the Nagaland Assembly. Or it could be something as basic as additional reservations in Andhra Pradesh. There's a whole spectrum of arrangements vis-a-vis the union and the states that shows that the diversity of the country is reflected in the diversity of its constitutional arrangements with various linguistic, ethnic, cultural groups and the center. And so that is the second axis. To what extent does the constitution require homogeneity, and how much can it accommodate diversity and pluralism in this regard? That is axis 2. Axis 3 is the state and the people. Right? So the preamble to the constitution begins with the ringing phrase, "We the people of India." But after we the people in the preamble have adopted, enacted and given to ourselves this constitution, the people disappear after that. So you wouldn't find any reference to them after the preamble. This is in variance from other constitutions, where often certain constitutions at the time of law making, time of law implementation, and the time of implementing constitutional change all require consultation with the people. So for example, under the Kenyan constitution, a constitutional amendment that seeks to alter a fundamental aspect of the constitutional text has to go through a referendum, and then there has to be a certain procedure established to that. A lot of American state constitutions have a right to recall, so you can recall legislators if you think they aren't doing their job. So basically, constitutional arrangements have a lot of space for people to participate, even beyond just elections. But the Indian constitution does not have that room or that space. It does come through in various laws, like the Forest Rights Act, which allows for Gram Sabha consent before you can take land, but only in laws, so it doesn't have a constitutional footing. So that third axis is the state and the people. The fourth axis, and this is obviously in the news a lot these days, is legislature and executive. So we have a Westminster parliamentary system of governance where the executive is meant to be answerable to parliament, and the executive can only last as long as it has the confidence of the parliament. That is formally our constitutional structure. But there are many interesting departures from that empower the executive at the cost of parliament. So for example, the anti-defection law, which is always in the news, effectively negates the possibility of intra-party dissent in parliament. So a party backbencher cannot vote against the party whip without losing their seat. And so therefore the party high command becomes all powerful, and the party high command is the executive for all practical purposes. Right? You have that. The speaker of the house is not required to be neutral. The speaker is not required to give up their party membership when they become the speaker. So whereas in the classical Westminster system, the speaker has to be representing the interests of the house against the executive. In our system, by design, and it's not about a bad speaker or a bad person in the office, but by design the incentive is towards the speaker being the voice of the ruling party, whoever the ruling party is at the center or the state. So many such provisions then ensure that the formal parliamentary system, which is meant to maintain a balance between the parliament as the representative body and the executive as the implementing body, skews towards the executive. That's the fourth axis. The fifth axis, which is also in the news right now in light of the Election Commissioners Bill, is the axis of the electoral bodies, which is the representative bodies, and what in constitutional language we call guarantor institutions. So a guarantor institution is an institution like the Election Commission, whose job is to basically run or implement an infrastructure without which a right would be meaningless. So for example, the right to vote will have no meaning without an infrastructure that ensures you can cast your vote in a free and fair way, in a way that is a secret ballot, and then can be counted and tallied in a fair and transparent way. And for all that, you need to have, of course, a body that implements that, Election Commission. Similarly, you have the Information Commission, the Human Rights Commission. In other countries and constitutions, you also have a Data Protection Commission and so on. So the purpose of these commissions is to stand between the executive and the people and ensure that certain rights are effectively implemented. And for that reason, the executive, in whichever country you look, is always trying to undermine these bodies. And the recent move to downgrade the status of the election commissioner from the equivalent of a judge to a cabinet secretary is part of that ongoing global story where there is a constant battle between these bodies and the ruling executive, trying to have a fight over terrain. So that is the fifth axis. And of course the final axis is rights. So rights ultimately are meant to balance power between the individual and the state. And the more rights you have, the more there is that balance of power between the individual and the state. And the fewer rights you have, the more it's skewed. So you have these, broadly these 6 axes along which the constitution organizes power. And if you look at it, that covers a significant part of the constitutional text. And the question and the key point is that none of these axes are set in stone. So at all times you have this constant struggle between these conflicting visions of power, the centralizing vision, the federalizing vision, the homogeneous vision, the plural vision, the people's participation being less or more. So there's this constant struggle going on in the constitution about who has power and how much. And every judgment of the court is one step in deciding which way that vision goes. And so think of it as a road. And every judgment is a fork in the road, where if you take one route, you will go towards a more centralizing vision of power, and the other fork will be a more decentralized, dispersed vision of power. And every court judgment then sets you down one path and closes off another path. And so think of judgments in that way as inflection points in the history of constitutionalism. And the broad point I want to make is that if you now, from this perspective, study the history of the Constitution, you will see that both in the constitutional text and structure and in judgments when they come as these forks in the road, there has been a gradual centralizing drift over time. So since 1950 up to now, there has been an incremental, gradual, slow drift towards a more executive-oriented, concentrated, homogeneous vision of power at the cost of a more plural, diverse, distributed vision. And if you look at cases, you'll see how it happens in different domains. Now, with that in mind, I want to take one example to illustrate this in about the 10 more minutes that are left before we go into the Q&A. And that example is from the classic federal history, the federal history of India. So there is a very famous case called State of West Bengal versus Union of India, 1962 Supreme Court. And I'll briefly discuss that case and end with that to illustrate this point I'm making. So in State of West Bengal versus Union of India, the key issue was the passage of a law called the Coal Bearing Areas Act of 1957. So under that law and under two supplementary statutory instruments passed under that law, the centre was entitled to acquire certain land in West Bengal for the purpose of mining coal. That was, in a sense, what this law and its instruments enable the centre to do. Now, the state of West Bengal challenged these rules and this law in the Supreme Court as a 131 suit, state versus Union of India, arguing that the constitution did not authorize the union to acquire state property of a state. Interestingly, many other states joined in this litigation because it affected a central federal question. So you have many states in the union back then taking part in this battle, and it was a 6-judge bench at that time. That was the full court, 6-judge bench that heard the case, and the main argument made by State of West Bengal turned upon entry 42 of list 3 of the 7th schedule. So just to explain that briefly, the 7th schedule, as many of you would know, essentially says that you have list 1, and list 1 has all the fields under which the union can legislate. So defense, foreign affairs, communication, many others. List 2 is the field under which the states can legislate. And list 3 is when both can legislate, with the rider that the union law would prevail over state law. Entry 42 of list 3 had the phrase acquisition or requisition of property. So that was the source or the field under which this law was being justified, that entry 42 of list 3 gives the union and the states both the legislative competence to pass laws on acquiring property, and therefore this central law is valid. But West Bengal argued that, look, there has to be an implied limitation under entry 42 upon the power that is granted. And that's because under the federal scheme, the union and the states are both sovereigns in their respective domains. And one fundamental organizing principle of all law is that a sovereign cannot acquire another sovereign's property compulsorily. It has to only be by consent. And therefore, the state of West Bengal argued that when you have the phrase acquisition or requisition of property, it actually should be read as acquisition or requisition of property except state property. So an necessarily implied limitation under entry 42 flowing from the federal scheme. That was the argument that the state made. By a 5-1 majority, the Supreme Court rejected this argument and they upheld the constitutionality of the law. And they did so on two bases, on the basis of two arguments. First was a historical argument. So the Supreme Court majority went into the history of pre-independence India. And they said, look, it was broadly a unitary dominion under the British rule. And gradually from 1909 onwards, you see evolutionary reforms happening over time. And with each successive evolution, there is more power devolved to the provinces. But at no point, the majority says, were the provinces ever independent or ever had their own identities. And so unlike the US Constitution where you had the 13 independent colonies that came together voluntarily and gave up certain power to the Union, in India it was the other way around, where you had devolution of power over time. And so therefore, at the time of independence, power passed from the British to the Indian people as a whole and was then distributed again via the Constitution through the Union and the states. So different history was given. And therefore, there was no warrant for assuming that the states ever had independent existence in their own right. That was a historical argument. This historical argument then merged or blended into the legal or the structural argument, which was that if you look at the Constitution, you will see throughout the Constitution various provisions that demonstrate this idea. Where, so Article 3, organization of state boundaries, the fact that if there is a law that cannot be traced back to any of the entries under the lists, the default is union power, the residuary list, for example, taxation of fiscal powers, emergency powers where the union can take over a state government under 356 of the Constitution for a certain time period, and many more. So the majority says that look at all these provisions. This clearly shows that the Indian Constitution's federal structure is meant to privilege union power over state power, and therefore reading the history along with the constitutional design leads us to the inescapable conclusion that where there is a conflict or a potential ambiguity or a silence in the Constitution, the interpretation has to be in the favor of union power, and so they upheld the law. Right? And if you read that this way, then that seems like a fairly plausible and convincing story. But the good thing about the common law system that they've inherited from the British is that there's always, within the court, there is no requirement of unanimity. So you have dissents that come sometimes. And in this case, there was a dissent authored by Justice Subba Rao, who is one of the most famous dissenting judges in our history. If you look at that time period, 1960s onwards, you will see in all domains Justice Subba Rao dissenting to the extent that his fellow judges were quite annoyed by how often he would dissent, and that's on record. They're not happy with that. So he gives a dissenting judgment in this case, where he contests both the historical reading of the majority and the design structural reading, where he says that, look, first of all, there was always a very strong provincial identity in British India. So you had provinces who had their own set of defined powers. You had the provinces with their own domains where they could make laws. And in fact, even in the Constituent Assembly, and if you read the debates, it was the provinces that sent members of the Assembly. So if you look at the debates in the Assembly, you will see so-and-so speaker, United Provinces, Jawaharlal Nehru, United Provinces, right? So-and-so speaker, Bengal, so-and-so speaker, some other state. So in fact, even in the Assembly, the speakers came as representatives of the provinces and not of the people as a whole. And so he says that, look, at the time of independence, there was what he calls, and what HMCY in his book, where he criticizes the majority judgment, calls a federal situation existing. So there was a diverse country with diverse linguistic, ethnic, cultural, groupings, which were reflected in various states, and that was the situation at the time of independence. So that's his historical argument. And his argument by design, therefore, is that, again, if you read from this into constitutional design, the very fact that where the Indian Constitution wants to depart from equal distribution of power, from center to states, it does so explicitly and expressly. Right? So wherever the Constitution wants to give additional power to the Union, there is a specific textual provision that does that, Article 3 or 356 or whatever, which in turn implies that when the framers chose to depart from an equal distribution of power, they did so in direct terms. And so whenever you have a constitutional silence or an ambiguity or a provision that can be read both ways, your default must be pro-state, because where they wanted to go the other way, there was a specific provision that said so. And so he reads both the history and the design in this opposite way, and says, look, the history shows you there was a federal situation, and that should inform the way you understand this text and this design. And ultimately, of course, therefore, the question is that what vision of the Constitution is more appealing to you as a citizen or to a judge or to a lawyer? And there in the dissent, the answer he gives is that ultimately a country that is diverse, is plural, is heterogeneous, is best held together if you grant and allow for a devolution of power. So the best way of integrating a country as diverse and as plural as we are is to pass power downwards. And that's of course a certain moral or normative vision of the Constitution that informs his reading of the specific provision. So in conclusion, the reason I wanted to talk about this case was that through the majority and the dissent, you see exactly how on the federal axis the Constitution is this terrain of contestation, and how in deciding that contest you need to go through multiple layers of interpreting the Constitution in terms of its history, its text, its structure, its design, and ultimately its overall purpose. So here the dispute was a very simple one. One sentence, in fact not even a sentence, so one phrase, acquisition or requisition of property. That's the core dispute. A classic lawyer's dispute, right? How do you read these 4 or 5 words? But to answer that question of how you read them, you then have to, you begin with the most concrete level, the text, and then you go deeper and deeper into the design of the Constitution, what the Constitution says about center-state relations, its history, how it has appeared in the British times, how it progressed over time, how that informs the text, and finally the broadest question is that what is the Constitution for, and what is that power meant to do, would influence how you read something as simple as these 5 words. And what we also see then is that people disagree over that, right? So the majority and the dissent gives you two very almost opposite views of both the history and the philosophy of the Constitution. This again shows that every constitutional provision is that terrain of contestation between different visions of power. And finally, and to end with this, that linkage between various axes of power, and therefore why you can't cleanly separate rights from structure. Couple of examples there. One is that you may have read in your constitutional law courses all the judgments pertaining to Tada and Tota and those special laws that depart from well-established criminal law principles, and provide a much more draconian structure. If you go back and read those cases, you'll see that whereas you think of them as fundamental rights challenges, Article 21, 14, and so on, the first and opening challenge in all those cases is actually a federal challenge. The first challenge in those cases is the basic argument that the parliament in the union is not competent to pass this Tada or Tota law because the fundamental issue deals with is public order. It's a state subject. Right? So in that way, your rights and the access to rights is directly linked with the federal structure and the scheme, and therefore how the Supreme Court would interpret the federal structure in a case like West Bengal will have an impact on many years later on how you interpret Tada or Tota and whether they are legal or not. So in that way, these 6 axes are all interconnected with each other, and the decision is like a spider's web. You pull on one, and the impact is across the whole web. So any case of this kind, it's not just one. As I said in the beginning, like think of it as a road, a forking path. There are actually many roads with forking paths, and one choice can then affect how all the other roads, fork as well. So that is, in a sense, the snapshot of this approach to the Constitution, a conversation with power, and this case an example of how that works. And therefore, I say that when you go back and reread the Constitution, see how it comes across from this perspective, and if that gives you any ideas about how to understand our constitutional document text and history. So with that, I will close. I think it's been exactly 40 minutes, so we can go into the discussion.
So we would now like to open the floor for the questions. First question is mine. So sir, I'm studying interpretation of statutes this semester. So while studying, I found out what the subject is, and I researched about subject. So I found out there is no principle of interpretation of law or constitution anywhere in the world where a provision can mean the opposite of what it says. So I'm referring to the second judge's case where judiciary interpreted the article 124 subclause 2 exactly opposite what it says in original text. So my main question is that can judiciary go to a certain extent where judiciary can legislate, or where judiciary can interpret and make laws in the purview of interpretation?
Yeah, so there is no bright line that distinguishes interpretation and legislation. It's always a question of degree. So, for example, you spoke of second judge's case where they interpreted consultation to mean concurrence. You have many cases where the word may has been interpreted to mean shall. Right? So the text says may and they read the shall, or the other way around. You have cases where, in fact, in the recent judgment on the PMLA, Vijay Vadanlal, which you would have come across a few months ago, almost a year now, almost a year ago actually, last year, the PMLA used the word and in its section that said about disjunctive condition, conjunctive condition. The court read it as or. So making it disjunctive, making it easier for the state then to sort of get you under PMLA. So the courts have read and as or, may as shall, and consultation as concurrence. So in that sense, this is quite standard. The question is that in the context of that case, is there something to justify that or warrant that reading? That's the larger question there. And in the case of, for example, in your example, second judge's case, there were two conflicting. Another example, Article 21, right? Procedure established by law. If you look at the debates of the Constituent Assembly, they considered due process, rejected that, and the Supreme Court says that actually we will read it as due process. So that is, it's there throughout. The question is that is it justified by the context? So in your case, the case you cited, so on the one hand you have the plain meaning of the word consultation. On the other hand, and you also have the debates in the assembly where Ambedkar says that we don't want the Chief Justice to become an imperium in an imperium. So you have that. On the other hand, you have the overall structuring principle that judiciary cannot be independent if the power over appointments is held by the executive. So that reading of the Constitution then has to comply with that principle. So then in that case the court picks the second alternative over the first. And the question is, do you find that convincing or not? Some people will, some people wouldn't. In the UK now, there is actually this the doctrine called Constitution compliant reading, where what they say is they have the Human Rights Act. And the mandate is that the court has to, insofar as possible, interpret any law to make it comply with the Human Rights Act. To think of that act as their constitution, just for the purposes of argument. Now, the UK courts have said that there is this Human Rights Act compliant reading that you have to do, and so therefore, as long as the language can support this reading in some way that complies with the Human Rights Act, we will pick that reading even if it is not borne out by the intent of the statute and even if the other reading is more convincing. Right? So as long as it is possible to support this reading on the text, we will interpret it this way. So in that way, you see courts all over the world saying, okay, we have like a constitutional document, we have a statute or a law that is potentially in conflict with it. We need to stretch it a bit to make it comply. And as I said, this is a question of degree. So in any given case, is it right or wrong is a matter of your judgment to see.
Good morning, sir. Sir, my question is with respect to the story of constitution transformation through the 9 judgments. So the story ends on the term the technological self-determination, which you said it is an abstract term at that point of time. But after passing the Data Protection Act in August, it seemed relevant to me, where an individual has no control to restrict government to access their data. And so my question mainly is that how should this act should be seen from the view that of data protection concern or data collection concern with respect to the constitutionalism that is controlling the government from using it.
Yeah, so I'm glad that you asked that, because actually the Data Protection Act is relevant to more than one axis that we discussed in today's discussion. So there are many problems with that act. So the first problem is that so any data protection law must establish an authority that will implement that law, right? So if you look at it across the world, GDPR or whatever, you have to have a data protection authority that will implement the law. It will receive complaints. It will decide on violations of the statute. It will issue fines and so on, right? And obviously that body has to be independent of the executive. So much like the Information Commission, because so many of your information requests will be against the executive. The Information Commission has to be independent of the executive. Similarly with this body, but the law basically brings that under the control of the executive. So the Data Protection Authority, whose job it is to basically receive citizen complaints against what the state is doing with respect to data hoarding or data collection, is under state control. Right? So that is one problem with the Act, and that's an example of the 4th branch or guaranteed institutions and that division of power. The other problem is that if you look at the basic core principles, there is this idea of proportionality as a legal doctrine, right? That when the state wants to violate or infringe your rights, there may be an overriding goal, an overriding reason to do that in some cases, but it must be proportionate to the goal. Right? So there is the German saying that you can't use a cannon to shoot a sparrow. Right? So in that sense, in this context, there are many different principles that have been evolved over time. One is purpose limitation. Right? So if you collect data, it can be used only for that purpose for which you collected it. And other agencies and other bodies can't then use that data, because then you have profiling, right? So you have that. Your data minimization is that the minimum amount of data that you need to pursue that goal is all you collect. That's the second principle. So all these principles have been sort of abandoned in the Act, thus allowing for widespread unchecked data collection. And the third, of course, problem is that there is a right that the government has under the Act to exempt any agency from the purview of the Act itself. Right? So any agency, any government agency can just be exempted from the Act. So that again is this overriding power the government has to ensure that a body can collect your data without even complying with those minimal provisions. So in that sense, looking at this from the perspective of technological self-determination, is that it obviously disempowers the individual and empowers the state with respect to the relationship of data between the individual and the state. And therefore, in my view, it's obviously very contrary to the constitution, but that depends on it being challenged and a judgment coming out, and we see how that goes.
sir. Sir, my question is, as India is a young evolving country, then what is the challenges and opportunities arises in defining the power of residuary power mainly, and by looking the scope of emerging issues in India, and what is the scope and boundaries that Supreme Court look by looking the power of residuary?
Residuary power entry 87 of list 1 is your question.
Yes, sir. So I will quote 48.
Oh, yeah, okay, yeah. No, that's a very good question. So, actually, the interesting thing is that when they were framing the constitution, the original cabinet mission plan was actually this confederation of three entities that would together form the Indian Union. And at that time, the residuary powers were going to be with the provincial units. Then Pakistan was formed and partition happened, and obviously many things changed. And so when the assembly met after the partition, they switched that clause. So they switched the residuary powers from state to center. And it's a very interesting thing you said about being a developing country, because actually there is a great article by this scholar called Louis Tillon, where she says that the reason why they did that was because of the political economy of the country. So they did not want different states, for example, engaging in a race to the bottom when each state tries to devalue labor standards, to attract investment, and each state then has worse and worse standards, and they wanted to have national economic coordination to be done at the central level. So because India was a developing country, and therefore the framers felt that the only way that development could happen would be under central coordination and not by devolving that to the states. And that's why they basically gave the residuary powers to the center and not the states. And so in that sense, your point there is basically the exact reason why they did that. I think it's a question of whether over the last 60 or 70 years that has actually worked out or not is of course the question that is there. The other interesting thing actually is that on that point, there is a very lesser known provision of the Constitution 293, which basically says that if any state is in debt to the Union, then that state cannot borrow any money without Union permission. Right? So, and basically every state is in debt because that's how the structure works fiscally. And so what has been happening of late actually is that and so seen during COVID time, for example, the Union basically was pressurizing the states to pass certain laws, like the Act of Electricity Act, on the basis that if you want to borrow money to basically fund your government, we will let you do it if you pass this act which allows for, say, privatizing electricity in the state or something of that kind. So in that way, the Constitution gives all these powers, not just residuary powers, but also various economic powers to the Union, which again, that's the question. Is that still necessary? Is that still a good thing or not? That of course is the question that is to be answered. But the reason is what you said, that the idea that a developing country has to have central coordination to progress is the reason why that is there in the Constitution.
So my question is, in the face of arbitrary exercise of power arbitrary exercise of power, and the Constitution essentially leaning towards the center with its power, how does one still believe in the Constitution? Like, I follow you on Twitter, so I know you constantly dissect judgments and you comment on that. So is there a certain nihilism that ever pops up in your brain when you're theorizing on it?
Sir, she is the one I'm talking about.
Yeah, I mean, nihilism is nihilism is perhaps too strong a word. There is certain, I guess, skepticism about the Constitution that perhaps wasn't there when I began working on it. But I think that there are two or three things. One is that it's a mistake to limit the Constitution to the courts. So if you look at our history, the courts have in many domains followed on from what social movements have done. So, for instance, something like the right to information is not something that the courts interpreted into the constitution, but it came about as a result of a very powerful social movement run by the MKSS in Rajasthan that ultimately got this law. The Forest Rights Act, is a law that came about as a result of a social movement. So, so many of the most progressive advances when it comes to rights or constitutionalism as a principle have not come through courts, but have come through other sources. So in that sense, a constitution is most alive, often outside of the courtroom, which I think is the reason why much of this still is meaningful and relevant. And the second is, of course, that the constitution is meant to still provide a blueprint, right, or a charter for how power might be organized in a certain way. And while there might be more and more of a gap between the charter and the exercise of power, there always has been that gap. The task of interpretation or practice or these kinds of cases is to try and narrow that gap a little bit. So even if you don't succeed in narrowing it fully, and that you'll never do, but even narrowing it a little bit in a case here, a case there is of value. So I think that is the answer there.
Good morning, sir. Executive, legislature and judiciary, this is a very conventional structure of division of power. However, according to you, sir, there is this one more wing which is called fourth branch institutions. Although the Constitution of India mentions these institutions, my question to you is, with respect to the structure of the constitutional text, why not the lawmakers of India adopted for this four-wing structure and stick to the three-branch structure?
Yeah, that's a fantastic question. The reason is that at the time the constitution was being framed, the vocabulary of the fourth branch wasn't really in existence. So if you look at all the constitutions that were framed around that time or before, and if you look at the constitutions that were framed in the immediate aftermath, so for example, in Africa, you had the first wave of constitution making in the 60s. So all of those adopt the three wings of state. It's only around the 1980s and onwards that this sense comes into being that you need a fourth branch that is not the judiciary and not the executive, but is performing functions that are overlapping with both. So if you look at constitutions framed after 1990, you see all of this there. So in the 1996 South African constitution, they have what are called Chapter 9 institutions. Chapter 9 is that part of the constitution of South Africa which has them. And then they have 6 institutions, Human Rights Commission, 5 Minorities Commission, Gender and Cultural Commission, and so on. So they have these 6 commissions. In the Kenyan constitution framed in 2010, you have a constitution, they are called integrity institutions, right? So they specifically say that the purpose of these bodies is to maintain integrity in governance, and then they have all those bodies. So I mean, it's a simple answer. The fact is that when our constitution was being enacted, they didn't have access to that vocabulary. It came much later. But there is also a slightly more complex answer, which is that some bodies obviously were there. Actually, Election Commission is a body that has always been there for a long time. But even there, so if you look at Article 324 of the Constitution, 324A, the framers did not even provide for the independence of the Election Commission in the Constitution. So what they say is, that look, Parliament will pass a law that will decide how the Election Commission functions. Until Parliament passes a law, the President will appoint, which means of course, the Prime Minister and the Cabinet, right? So in that sense, even the fourth branch bodies that were known to the framers, they still saw them as executive adjuncts, which has created a lot of problems, because now of course you have the new bill being tabled, and the fact that when you want to say place the independence of the Election Commission on a constitutional footing, it's much harder because the text is silent, which makes it easier for the executive to get around that. So I think it's One is that to sum up that many fourth class bodies didn't exist at the time, and even though they existed, the framers had a lot of faith in the executive, which has perhaps over the years been misplaced.
We have just paucity of time, so last
up to
last
you.
one or two
Up to you.
questions.
I'm good. Up to you.
The lecture. Last two. बाहर पूछ लेंगे हम.
Good morning, sir. As you said that when there's any uncertainty or ambiguity in the constitution, we have to go pro-state. But my question is, sir, that why must we abide by the constitutional ethos of the founding fathers? As the name says that they're founding, but the constitution is a living document and the ethos changes as the time changes. And I'm not sure whether this is correct from a jurisprudence perspective, but India is also a party to the International Covenant on Civil and Political Rights, and we have the right to self-determination. So would that be applicable here in determining our own ethos as time evolves?
Yeah, so I think that's a good point, and in fact, it's interesting because in many facets that plays out in interesting ways. So, for example, if you look at Article 3, right? If you look at the ability of the Union Parliament to alter or reorganize state boundaries without even the consent of the state. At the time of independence, actually the nature of the states in India was quite wasn't corresponding to any particular linguistic or ethnic or cultural claim, because the British had basically had divisions on administrative grounds, right? So all those states were effectively of that kind. In 1957, 56. The reorganization of states on linguistic grounds in response to these claims. After that, on many occasions, you have the creation of states like Nagaland, Mizoram, Manipur, all out of Assam. Originally, you had Assam as one state, with the capital being Shillong, and then you have over time, in response to these of self-determination actually, right? These claims, you have new states, and so now in this day and age, the states are not the kinds of pure administrative entities that they were in 47, but actually have a certain identity as linguistic, as cultural, set of peoples. So in that way, interpreting Article 3, for example, you would want to say, okay, at that time, perhaps the power meant something because the nature of states was different, now it's very different. And that should actually impact how we interpret Article 3. So for example, in this Kashmir case, the question being that can you convert a state to a centrally controlled UT is the question, right? And I think that the fact that back in 47, it didn't matter all that much because states were not what they are now, should play a part in interpreting Article 3. So I think you're right in that sense. It's an example of how that might work in practice.
This is the last question for the day.
So one last question. Sir, as you have talked about separation of power and have talked about the federal stand of where India stands. So the fourth axis and the fifth axis that you explained, the defection one and the election of the election commission, sir. Therein we can see, sir, whenever we have, this is a very common question which arises while studying constitution or while studying administrative law, is that there, to my view, I might be wrong, there is an unfair advantage to an executive. Voting is the most basic thing, and election commission the appointment of election commission is the most crucial part which maintains the fair voting criteria and everything. So executive, there's way too much overlapping between executive and the legislative part, and executive is given an unfair advantage. How does that stand in consonance to the ideals of democracy and the fair running?
Yeah, so in fact, if you look at the concurring judgment in the Anup Baranwal case, which was the election commission case, Justice Rastogi actually has a table of how other countries appoint election commissioners, and he says that the Indian situation of the executive appointing it actually is outlier. So almost no country gives this power to the executive. So I think that so you're right in that on both axes there is this struggle where the executive dominates parliament by virtue of the anti-defection law and the speaker's role and money bills, all of that, and the executive dominates these institutions, election commission and so on, and both those obviously create problems. And the answer is that there are all kinds of models where that doesn't happen, right? So, for example, mandating speaker neutrality in the constitutional text, thereby ensuring the speaker cannot misclassify bills as money bills and take out upper house scrutiny. For this is one example, right? And also in these bodies, all other countries have commissions that appoint members of these bodies, and the commissions are meant to be either non-partisan or multi-partisan, right? So either you have a completely non-partisan appointing body where people not involved in politics appoint, or you have an equal balance between the executive and the opposition in appointing the election commissioners. So I think you have all these models. I think the problem is something that we come back to, which is that the original constitutional text is executive heavy. It's sort of executive heavy and it's front-loaded towards the executive. So whenever you're trying to decentralize power away from the executive, you are in some way going against the constitutional grain through a judgment or through a legislation. So that struggle is a struggle that is there because the original vision was executive heavy, and we're trying now to devolve, but it's like it's hard because of that, right? So we are pushing against the text. But that's of course a much longer struggle, and we see how that goes.
The best question asked by
Who decides? Who decides?
They're all great questions. All great.
yeah. So Yashaswini Parashar.
Thank you very much, sir, for such an insightful session. I stand here today as a very proud member of Society for Constitutional Law and Human Rights to express my heartfelt gratitude towards each one of those who made this event a successful one. I would like to start by thanking our Dean, sir, our faculty convener, sir, Mr. Ashutosh Tripathi, sir, for their relentless and unwavering support, which has been indeed instrumental in making this event an actual success. I would also like to thank the members of Society for Constitutional Law and Human Rights who have been always there with us and participating in making this event a success. I would also like to thank each one of you for being here with us and showing your presence. I would lastly like to thank our guests, sir. Like, considering the paucity of time, we could not entertain all of the questions, and we apologize for the same. However, we would really want to have you again with us for a much prolonged session so that we could have a more insightful and fruitful discussion in times. So thank you so much for that, sir. Thank you.
With this, we have come to an end of this guest lecture. I would now like to thank our guest speaker, Mr. Gautam Bhatia, sir, Dean, sir, faculty convener, Ashutosh Tripathi, sir, and all the teachers and other staff members and all students present here to make this guest lecture memorable and worthwhile. Thank you. You all were an amazing audience. Thank you. You all are requested for IT outside School of Law and a picture with Gautam Bhatia, sir.